We are back on the record on JU 168801 in the matter of John Doe, otherwise known as Baby Boy Holm, in some pleadings. Parties are present with counsel, also present the foster parents, and Mr. Kirby, you have another gentleman seated at your table who was not here in the last hearing.
Yes, ma'am. And we need to address the court, I guess, before we get started on motions as to possible witnesses being present in the courtroom and Mr. Brady Byrum.
I was going to say I'd like to ask if he could assist in counsel.
Mr. Byrum will be here solely for the purposes of taking notes, and he's a friend of the parents, a longtime friend of the parents. And Mr. Byrum, you understand that everything that's said in this courtroom is confidential, and you can't disclose what goes on in this courtroom outside of the court.
Absolutely.
Okay. We'd ask that he be allowed to stay and assist the parents with notes if possible. We believe that's allowed under under 12-15-129. Says the general public should be excluded from delinquency and need of supervision and dependency hearings, and only the parties, their counsel, witnesses, and other persons requested by a party shall be admitted. Other persons, as the juvenile court finds to have proper interest in the case or in the work of the juvenile court, may be admitted by the juvenile court on condition that the persons refrain from divulging any information which would identify the child under the jurisdiction of the juvenile court or family involved. So we're asking for Mr. Byrum to be admitted into this proceeding. He understands that he's not to. He understands that he can assist them by taking notes, and he's not to disrupt this court in any way.
Or argue any motions.
Mr. Byrum, a licensed attorney.
Your licensed attorney, Mr. Byrum?
No.
Department's response.
Your Honor, we would object to him being present. He is not an attorney. A brief internet search of him actually appears that he is here and has been providing legal counsel to the Holms, which would be the unlawful practice of law, and that we believe that is the sole reason why he was present. Mom and Dad are both here. They are able to take notes. That's what the department is doing. Its counsel has to take notes as well in order to be prepared. They have standby counsel. They have plenty of assistance to ensure that their case is able to be recorded and they're able to put forth the evidence. And again, he is here solely for the purpose of attempting to provide unlawful legal advice to the Holms.
Guardian.
I'd like to have on record that... Oh, I'm sorry.
Guardian.
Judge, I would also object and echo the argument of the department for this motion.
Mr. Holm.
Yes, ma'am.
Go ahead.
I'd like to state on the record that it's our Sixth Amendment right to have counsel of our choice.
Ms. Holm. Anything further, Mr. Kirby?
Nothing.
Okay. It has long been the standard and practice of this court that if everyone does not agree that someone that is not a party under the rules or not an attorney is not allowed to come in, Mr. Byrum may indeed, I guess, be called as a character witness, maybe even. If he's known these people a long time, I don't know. I just don't think it's proper to allow him to remain in the courtroom to assist in taking notes. Your client is very capable of doing that.
Respect the court's decision.
I'd like to have it on record that our Sixth Amendment rights are being violated.
Okay. Judge, before we get started with any motion, would it be proper now to ask that any witnesses be asked to leave the room? Any possible witnesses be asked to leave the room?
The rule's been invoked. If you're going to testify, you need to leave, with the exception of whatever our standard has been, that the, generally, if it is the state gets to have their person in. So, I mean, who are you asking them to leave?
Well,
You want them to designate one?
yes.
Okay.
And I also want to know who everybody else is.
Foster parents are in the back. They're Mr. and Ms. Cash.
All right, Ms. Busby is subpoenaed as a witness for us. Ms. Smith is subpoenaed as a witness for us. Foster parents may be possible witnesses.
Foster parents have a right under the statute, is my understanding, to be here.
Is that Alex?
That's Alex.
Okay, I'm sorry, I didn't know you, Alex. But she's definitely subpoenaed.
Alex
Martin.
Martin.
Okay. So if the state would like to designate one agent for them, I understand that. And if by statute the foster parents can stay in here, I'm not going to argue with that. But certainly Ms. Busby is subpoenaed as a witness for the parents. And we'd ask her and Ms. Martin.
State's response.
Judge, if I can have 1 second.
And while y'all are doing that, if you want to remove your jackets,
Thank
you may. It's a little cool in here to me, but I'm cold-natured, and it was rather stuffy in here when we came in.
Judge, we would designate Ms. Smith as our case agent.
Okay. Ms. Martin and Ms. Busby, if you'll step out. There's no one in the large courtroom, so you may utilize that area over there if you want to. Okay, we have several pending motions, and I apologize, I've got to get down to where they're at. We were last here on December 5th, and we took up a few motions then, which were addressed. Is that, did I get all of them at that time?
To my knowledge, at that time, Your Honor, I believe so.
Well, at that time, we addressed a motion to comply, which was motion for guardian ad litem parents. We took care of that. The motion about the child's name, that was taken care of. The motion to hold an open court, that was taken care of. Were there any other motions pending at that time?
None of that time, Judge.
Thanks.
Well, there was a motion to dismiss, and I think you held that in abeyance.
That wasn't filed until the 6th.
Okay.
Right.
There was, and I have it as a 10-page docketed motion, and I'm not sure that the parents intended for it to be docketed as a motion they filed in, and we did not address it. It starts with the manufacturer's statement of origin. And I think it was actually marked as maybe Exhibit 3 or 4. So was that something that you wanted to argue, or was that just something that was filed in? It's here. It's this right here. Let me see how many pages it is.
That's not something that's intended to argue.
Okay, it was a 10-page. Okay, that's what I thought, but I just wanted to make sure. Okay, so I guess we'll just take these in the...
Let me confer with the parents.
Sure.
You didn't have anything here that you wanted to argue. You just went on and just give them.
That's correct. We didn't file that.
Well, I think that was, oh, this is State's Exhibit 2, I'm sorry.
Nor did we file this.
You didn't file one?
No, we didn't file these either.
You didn't file these?
No.
Okay. Parents state that they did not file this.
Okay, yeah, well, and it may not have been marked. So these were things that were,
I think that was filed.
these they took to them.
Okay.
But what I showed you is a 10-page statement of manufacturer's origin.
Yes, ma'am.
That was actually brought up to us by Tony Hamlin was trying to cross-examine.
That's right. That's
Yes,
the
those-
state's exhibit.
Right. Okay.
But I think it is made part of the record as a.
I think that we did enter an MSO that was looking at, no, we didn't.
You said it's in our court as a docketed motion.
There's 10-page docketed motion. I'm sorry, our internet is so horribly slow.
This looks like it's more than 10 pages.
Yes, it is apparently not the same document from what you're telling me. 'Cause
Okay.
the front of that document and the front of this document do not appear to be the same, and
Okay.
this one was actually stamp filed in December 5th in the clerk's office. And it starts manufacturer statement of origin.
That's it. That was, the state attempted to introduce that. Okay. But it is part of the record.
All right, so we have, let's take care of this issue. The transcripts, we've taken care of that. Is that correct?
Yes, ma'am.
There's a motion to revoke permissions given to DHR as filed by the father, I believe, and possibly the mother both.
Yes, ma'am.
I'm unsure that should be a motion. I think that may have just been noticed to the court. Is that correct?
Okay.
That any HIPAA authorization that they've given had been revoked.
Was that being addressed?
And then we have a motion. I'm sorry, Mr. Holm.
I was just wondering if that was being addressed.
Do you want it addressed any further?
I just need
I mean,
to know.
you have a right to tell me what you want to
Yeah.
tell me about it.
Is it being revoked or not?
I think the simple fact that they put on there that they revoked their permission. I mean, you can revoke a waiver, you can revoke a power of attorney.
I'd just like to have it on record that we were under duress.
Mr. Slinker, what's your understanding of that? As far as the...
Your Honor, my understanding of HIPAA is that they can, when they elect to, allow the release of information, and they can revoke it. They have notified the department. I don't believe it had anything to do with the court. With regards to duress, obviously, A, that did not occur in court, and B, we would certainly take issue with it being under duress. I believe it was part of an ISP. They were represented by counsel at the time, so there was no duress. But again, I think they can certainly have revoked it. It does not change the reality of the fact that if the department has received records prior to the revocation, that it still has those records.
And I don't think it's something that that's up for me to determine. That's the way I have always viewed it. But that lies with the discretion of the person whose records are being sought. Just like you said, like a power of attorney.
Mm-hmm. Yes, ma'am. You understand that? Okay. You good?
Yeah.
All right.
Okay. All right, then we have on the 6th a motion to dismiss filed pro se by the parents. And on the 7th, a 29-page motion to dismiss filed by the parents. So if we're taking things in order, Mr. Kirby, you and your folks want to argue those two motions now, or do you want to argue all the motions to dismiss together in one bundle? And there was also a motion to dismiss, a notice filed this morning, or last night at 4:42. Which I did not see until this morning, and then a motion in limine. And then we have the motion to alter amend as filed by the state as to records which were filed before the motion to dismiss was yesterday afternoon, and the motion in limine.
sorry, Your Honor, I'm looking for the 27-page motion to dismiss.
Mr. and Ms. Holm filed it, I believe. It was before you got involved.
Handwritten.
I know there was a motion to dismiss based on lack of evidence filed by the Holms on the 6th,
Yes.
but I don't know, there wasn't.
There wasn't 29 pages, it was just one page handwritten.
But then
We included the case laws.
29
I think that
pages,
was the
yes.
next day. I think
Okay.
they filed.
One was filed the
motion to
6th, one was filed the
dismiss. Yeah,
7th.
The second one was the longer one.
Okay, all right. We'll just, we can address all the motions to dismiss at the same time, Your Honor.
So now we get to addressing all the motions to dismiss and everything in order. The department filed a motion on December 9th titled to alter or amend production order. That was set for a hearing today. And department?
Your Honor, the department filed that petition, that motion seeking to change the court standard production order. While we respect the court and its attempts to give regularly licensed attorneys access to the department's records, we certainly have concerns with regards to Mr. and Mrs. Holm having unfettered access to the agency's department. Specifically, we would point out the fact that the Holms have a history of taking whatever information they glean and within 24 hours putting it out on social media or the like. And again, it is our concern that those records would not be used for the purposes that they would be intended or that they are intended for, which is for the purposes of preparation for this hearing, but instead would be used to further promulgate whatever it is that they're attempting to do on social media. Again, if they had regular counsel, the department would certainly have complied with production prior to that. But again, as an example, within 24 hours of the last hearing, it was on social media, particular evidentiary issues that had come up in this hearing. For instance, specifically, I should say, not for instance, specifically, the issue with regards to the department being able to get in the records, there was actual comments on Facebook by one of the Holm supporters, specifically addressing the fact that those records were not able to be admitted at that time, and then theorizing other things that might occur. That is of grave concern to the agency. It's also grave concern to the agency as well, again, that whatever is happening in this case is being instantly turned around and put out into media. For that reason alone, we are very concerned with the release of our records. They are confidential in nature. The parents do correctly in their response. Say 2614.8 says parents have a right to use it for purposes of a dependency case. The problem is that that's oftentimes not the Holm's purpose. Their purpose is to, at least it appears to be, have a cause to go down and picket, to put out whatever it is that they're trying to spin on media. And again, that is the agency's concern. There are other statutes that make other portions confidential. 3826. The Holms rely on that being only about welfare. If you read you cannot take 3826 outside of the context of 38.2 in general. 38.2 is the actual enabling statutes for the Department of Human Resources and its existence. 38.26 goes through and talks about DHR's records, and then it actually says there's actually a period that the Holms then kind of skip over, and they say, okay, well, that applies to public welfare. At the end of the very statute, it says that the release of those records is a misdemeanor. Again, that is exactly what the Holms intend to do. So we are concerned with giving them those records because we believe that they will instantly or almost instantly be into the public domain. Additionally, many of the records that the department has, the Holms either have or have access to. For instance, we have a copy of Mr. Holm's psychiatric records. Mr. Holm has access to those records as well. We have the child's medical records. They have gone to RMC and procured those records. They have gone to the doctor's offices and procured those records. So there is very little in our record that they have themselves not had direct access to, should they have elected to have undertaken to have gotten those records. So for that reason, Judge, we are opposed to releasing these records to the Holms and would ask that the court modify its order.
Modify it to?
Judge, we would ask that there be no release of these records to the Holms, or in the alternative, that they be only allowed to be given to, and again, I don't know that this is appropriate because Mr. Kirby is only standby counsel, but again, perhaps the standby counsel with a caveat that they are not allowed to make copies of them or anything else, so that way, again, that those records cannot be directly released to the public.
Your Honor, let me say one thing. Your Honor, this is a diversion tactic to hide injustice.
I would like to address Mr. Slinkers.
Judge, I object to Mr. Kirby. Mr. Kirby is not their attorney. They represent themselves. He's merely standby counsel.
Before we entered court today, the Holms have authorized me to argue the motions that I've assisted with them in filing, and they've authorized me to address some witnesses in the case.
Judge, we would ask for a limited notice of appearance for those
That's correct.
purposes.
Yes.
So that is correct.
Yes.
Okay. This is the issue that I have with that. Either you're standby counsel or you're counsel. If you're counsel, you argue, you question. Mr. and Ms. Holm don't get to do that. We can't have both, is my understanding of the rule, of the way that these things work. Mr. Kirby, if you have a different understanding, please. And if you need to take a few minutes with Mr. and Ms.
I do.
Holm,
I like,
that's fine. I certainly understand, and that is, but that's my understanding of the way that our court system and process works.
Mhm.
I think you're allowed to cross-examine a witness, but two are not allowed to cross-examine the same witness.
So the court's advice is either one or the other.
Well, I appointed you as standby counsel to assist them, to help them better understand, because the dependency process in general is a very difficult area of the legal system.
Yes, ma'am.
And certainly within their, what they were comfortable with, because they did want to proceed pro se, to give them assistance with, possible research and filing of motions, which I think is well within the purview of standby counsel to, especially in light of some of the things that do appear in the filings that occurred prior to counsel being on board. But as far as actually questioning and things like that, it would in essence allow the parents to, for lack of better words, double barrel a witness, which is exactly what I warned Mr. and Ms. Holm the department would not be allowed to do, nor would they be allowed to do when we started this and they chose to proceed pro se as a unified couple, because they are married. Just like I would not allow Mr. Slinker and then Mr. Hamlin to do that.
Is that just to one witness that's on the stand, or is that going to
That's
apply?
what we were told, I think, in the beginning.
Because I think the explanation of the court on December the 5th was, you explained it to them, but that they could not both question.
Correct.
Just like you wouldn't let the department question the witnesses, or, took both council members from the department, question them at one time. That was my understanding of it. But I mean, they've asked me to assist, of course, in filing motions,
Sure.
and doing the research on it, and they've asked me to assist, since I've done the research on it, to assist in addressing the motions that have been filed. I don't know whether that goes beyond the standby counsel or not. But I would say certainly getting records would getting records would be, if the parents ask for assistance to get records, that would be an issue that standby counsel could help with.
If you want to take a moment and speak with Mr. and Ms. Holm, you may, to see what direction they would like to proceed, because they may very well or may not, I don't know. Okay, they may very well say at this point, Mr. Kirby, we want you to question people, which does change your role, which is fine. It just changes the flow of how things may progress today as far as who gets to question witnesses and make argument. Okay.
Well, I can answer. We see ourselves as counsel. We see him as counsel, and we.
I think you need to take a moment to address.
We'll
But
have
let me let you take a moment to address this with Mr. Kirby, okay? Just to make sure. We're back on the record on baby boy Holm and Mr. Kirby.
Yes, ma'am.
We were discussing about standby counsel.
Yes, ma'am. The Holmes and I discussed it. Our understanding was that when you said you couldn't shotgun witnesses, it was not that they couldn't be considered as two counsels. Of course, the state has two counsels here. And I'm assuming that either one of them could take a witness and the other one couldn't question them, but that
Correct.
either one of those. So I think what the Holmes want to do is ask that I be co-counsel with them, just the same as the state has co-counsel at their table.
Equality of law.
I'm sorry.
Okay.
Did Mr. Holm have something
He just said equality of law, Your Honor.
evolved?
Equality of law.
Okay, thank you. Mr. Slinker, anything further?
No, ma'am.
Okay. Guardian?
Judge, I don't have any arguments on this issue.
I think at this point, what's the harm in extending it? Unorthodox, somewhat, yes. But by the same token, Mr. and Ms. Holm have allowed and need assistance, I believe, is what they're saying in arguing some motions. So, if you're going to be sitting there writing notes to them, let's just go forward.
Okay.
Now,
Forward.
the department had made their argument as to why they do not want these records released and for the court to amend my prior order.
And Judge, we believe that your production order doesn't give the department the option to not provide those records. The parents were acting as attorneys on their own. They should have received them as the attorneys of record in this case. Even after the appointment of standby counsel received or requested those records from the department via email, and I sent somebody up here not only to serve subpoenas but to pick up those records last Friday. They were refused. Those records were refused. We're saying that we certainly have a right to inspect those records and use what is available in a trial of this matter. Just like item 6 or paragraph 6 in our additional objection to the state's motion.
Okay, wait, tell me exactly which one.
This is the parent's additional objection to the state's motion to amend production in the 9
What day was that filed on?
That was filed on December the 12th at 6:36 p.m.
Let me get to the right one. It's the supplement to objection.
Yes, ma'am. And let me go back and, if I may, address the department statements that the Holms are divulging information on social media about this case. That's my understanding is that's not the case. The Holms have had their court records since December the 6th, all of their court records since December the 6th. I provided those records to them, printed them all out off of Alcor, and I would ask the state if they have any proof if those records have ended up on social media.
All right, either, and that is the, hang on, forgot what that was titled.
I'm sorry, what?
I'm sort of taking them in order here.
Yeah. The
Motion to produce evidence of service was what that was titled.
No, ma'am. That's something completely different. The court's production order is what we're arguing here, and it says
Right, but you were asking for them to produce evidence of dissemination on social media,
Right,
and in
that's
the bottom of this motion to produce, the other motion that we're talking about, produce the hearing scheduled, all evidence they have that will support it, service of motions. Okay.
Yes,
All right.
ma'am. No, that's
Okay, that's a different
matter.
animal. All right.
Yes, ma'am.
I'm closing that one out for right now. And
Okay.
closing it out, I just mean shutting it out on the screen.
I understand. But if the state's going to sit over there and make the allegation that what the Hollands are doing are divulging information on social media, they may need to show some proof of that. Like I say, they've had the documents. They've had all the court documents since December the 6th. I know. I gave them to them. Okay? As far as I know, now, I don't go trolling people's Facebook or anything like that. As far as I know, there's no documents that have been produced on social media. And quite honestly, Your Honor, the protective order that's issued in this case is based on the identity of the child, okay? Not revealing the identity of the child, specifically 1215-129. General public shall be excluded from delinquency in need of supervision or dependency hearings, and only parties, their counsel, witnesses, and other persons requested by parties shall be admitted. Okay? Other persons as the juvenile court finds to have proper interest in the case or in the work of the juvenile court may be admitted by the juvenile court on the conditions that the persons refrain from divulging any information which would identify the child. Further in that protection order, the court cites KR v. Lauderdale County Department of Human Resources, citing specifically about disclosing the name of the minor child made the subject of the action to any person or entity in a manner that will allow the child to be identified as involved with this juvenile court proceeding. And B, discussing the juvenile court proceeding with any person or entity in a manner that would allow the child to be identified. So, based on that, the court's protective order is all about the identification of the child. The child has a generic name that the court has assigned for court purposes. The child is not named. Matter of fact, the court denied the department's motion to name the child at our last hearing on December the 5th. So what I'm saying is it's impossible for the parents to identify the child. The child is not yet named, other than a generic name given to many unknown children in court proceedings. So I think we've addressed the allegations, and if Mr. Slinker has evidence that there's been documents that have been entered into social media, I would, I might understand that argument for not giving us the records from DHR. But I don't know of any. Like I say, I don't do that. I don't go around looking for stuff like that. The state cites 4 statutes which deal with confidentiality of DHR records. First being Code 2614-8, child abuse and neglect records, They don't specifically state what, if any, subsection applies. But by that very statute, subsection C says that subsection A deals with indicated and not indicated definitions. Subsection B is a central registry for reporting child abuse and neglect. Subsection C, access to abuse and neglect records, which states as follows. The department shall establish and enforce rules and regulations governing the custody, use, and preservation of reports and records of child abuse. Child abuse and neglect reports and records should be limited to the purposes for which they're furnished and by the provisions of law which they may be furnished. The reports and records of child abuse and neglect are related information or testimony shall be confidential and should not be disclosed for any purposes other than to, and it lists them out there, but more specifically, subparagraph 6 of section C says for use by any person authorized by court to act as a representative for an abused or neglected child. We would make the argument that the parents, I can't speak for Ms. Wilkinson and Ms. Argo, but the parents, I don't know that they were providing any records. I kind of doubt they were, since they weren't in the case very long. But from the time Ms. Wilkerson and Ms. Argo were filed their motions to withdraw, the parents have been acting as the attorney, and they've not been provided any records. And the records should have been provided to them by your production order. It doesn't give the option. It doesn't give the state the option of producing those records. It says they shall be produced, not they may be produced. Okay. And subparagraph 8 says for use by any attorney or guardian ad litem in representing or defending a child or his parents or guardians in a court proceeding relating to abuse and neglect. The very statute that the state cites allows the production of records to those parents. They're the attorneys of record. As of December the 5th, I was the standby counsel appointed to assist them, and specifically in getting the records they needed to prepare a defense for this case. I've been denied that. They've been denied that. It doesn't give them the option. We think your production order stands is good. It doesn't give them the option to give us those records. We should have been given to them. If they gave them to us today, the day of trial, there's no way that we would have enough time to examine those records and continue this trial today. And I don't think the parents are wanting to continue this matter. Let's move on. It says the state also cites section 32 or 38-2-6 subsection 8, and that states the aim of the department shall be promotion of unified development of welfare activities. Activities and agencies of the state, the local governments. I'm not going to finish reading that, but subsection 8 says establish and enforce reasonable rules and regulations concerning the custody, use, and preservation of the records, papers, files, and communications of the state and county departments. The use of such records, papers, files, and communications by any other agency or department of government shall be limited for the purposes which they are furnished and by the provisions of law of which they are furnished. The parents are going to contend that the above side that the statute that the state cited deals with applications and records for public assistance by the department. Let me back up just a little bit. Their records for public assistance, and I'm assuming that means food stamps and welfare. This and it talks about divulging those records to grand juries and circuit courts. It doesn't have any application to attorneys of record or standby counsel. So the statute they cite doesn't deal with the records that are sought here. State further cites 38713. Judge, these are child care licensing records that particular statute is addressing. It's spelled out in the motion, but child care licensing statute has nothing to do with what's going on here today. They further cite 389-6, subsection E, adult protective services. Now, adult protective services, not child dependency cases. The child here is not an adult. It is a child, a minor child. So we would contend that statute doesn't apply to us or to the Holms. And, Your Honor, I think the filing of this was just a stalling tactic just to keep us from getting the records that were requested. Like I said, I sent my assistant up here to serve subpoenas on Friday and to pick up the records, and that was what was requested by the Holms. And we were denied access to the records then.
Anything further? Do you want to let the guardian argue her position while y'all, or do you need a moment? Guardian?
Yes, Judge. I do believe that parents and or their attorneys have the right to have records. At the same time, I understand the department's position about concern for those being released. At the same time, I have a copy of what I believe is the department's record. The only things that I'm aware of that the parents don't or could not have access to would of course be the department's narrative and the can, which from what I have is we're talking about a very limited amount of information. Most of everything else I have, I believe that the parents have access to. So as far as having access to that, they would be familiar with what was contained in those records. I believe Mr. Kirby addressed an issue as far as asking if the department had proof that any of these filings or pleadings or anything have been released to the media. I myself am not aware of any, not saying that there is or there isn't, I'm not aware of any of the actual pleadings being released, but I am aware of what I consider to be confidential information that was testified to and about in the courtroom at the hearing on the 5th being released on social media, which does cause me concern. I understand that the child has not been named, but I don't think that fact in and of itself protects the child's identity. Just because the child doesn't have a name doesn't mean people don't know who this child is.
Judge, first off, they are you have two names for this child in the file. One is John Doe. The other one I understand is baby boy Holm. They are standing on the streets with signs that say #baby Holm. That is directly related to this child. They have a site on Facebook for free #FreeBabyHolm, wherein on, I believe this was Tuesday following the last hearing, someone posted, "Can anyone out there help me with a few legal questions? There are a few things that happened during the trial that raised questions for me regarding the legality of Judge Melody Walker's decisions. First, the decision to prolong the trial was done against the parents' wishes due to witnesses testifying on behalf of DHR not being present. If one of the parents' witnesses wasn't present, I doubt the trial would have been prolonged. Second, evidence in the form of paperwork was trying to be admitted in evidence on behalf of DHR that wasn't certified. That was objected to on the grounds that the documentation wasn't certified and was denied as admissible by the judge. At the next hearing, I'm guessing that paperwork will now be certified and try to be admitted then by DHR. If the trial was finished on the 5th, then this paperwork would have never had a chance to be admitted in the first place. It is my thinking this is part of the reason for prolonging the trial. Third, counsel on behalf of DHR, parentheses prosecutors, Judge Melody Walker and the baby's attorneys entered in an outside room and denied Christian Holm access to the meeting to see what was being discussed. I'm no lawyer, but these actions seem biased and one-sided towards the parents and seem to lean towards siding with DHR. Please let me know if anyone can validate my concerns of Judge Melody Walker's actions. Thanks to all who are helping. Then they also, 2 days later, they had filed with this court a pleading regarding their referral of this case to the FBI on a website called Medical Kidnap. That is referenced, as well as very similar things to what I just read. And then there is also updated 12/13/16 hashtag Free Baby Home Awareness Event. So again, there is an attempt to disclose information about this case. And while it may not be the actual document itself, it is nonetheless the information that is contained in those records that is being seeped. And again, that is the concern of the agency, is that information is instantly being put out, and it is affecting the identity of this child. Because again, he has actually 2 names, John Doe and baby boy Holm, and again, it is identified with the parents as well. This is in the now the public domain. Again, and I will just go back to 3826 says that they are limited. Records are limited for the purposes which they are furnished, and then violations of this provision shall be a misdemeanor and punishable accordingly. So again, it is illegal for the release of those records. And again, that is the concern of the agency, is that these records will not be used for the purposes for which they are created.
Mr. Kirby?
Your Honor,
No, you believe, I'm going to be co-counsel, you need to let me argue. You got something you need to push me. Your Honor, I would ask Mr. Slinker, where did that information come from? Was it off the Holmes Facebook page?
And it's off of hashtag Free Baby Home, which is a Facebook page set up by them and their supporters with regards to this case.
Can you prove that it was set up by them?
Obviously, I cannot.
Okay.
But on the
Judge,
same hand, though, Judge, there is no
that-
reason why. There is no place else that information would have come from. It would not have come from the agency. It would not have come from the GAL. There's one source of that information, that would be the Holmes.
Well, there was a number of people in this hearing December the 5th, and it doesn't mean, a number of people, more than there are in here now, and it doesn't mean that it came from the Holmes. Even if it did, Judge, it's not a document that's entered into social media, and it doesn't Baby Holm is the generic court name for the child is John Doe, or baby boy Holm. I think anybody would assume that baby Holm, could be their child. But it doesn't name that child specifically because that child doesn't have a name to be addressed. Now, the department tried to name that child Malachi. I think it was Malachi. And you denied their motions to name that child Malachi because it was not the parents' wishes. And we believe that to be proper. Judge, as a pattern of practice with DHR, they've been given the attorneys of record, the attorneys of record, the records prior to coming to court. That's just a pattern of practice with DHR because that's what your order says. We think they should have to abide by that order now, and probably the fact that they haven't they should be found in contempt. Even after the appearance of standby counsel, I requested those records to discuss the defense of the Holms in this trial today. Those records were denied to be given to me. I'm a regularly licensed practicing attorney in the state of Alabama. And even though I was standby counsel, one of my duties as standby counsel was to get them records that they needed for trial. Now, I'm not sure what's all in DHR's records, but it could very well be something that was used today in their defense. And the other criminal cases that the state cites in there, that has to do with the defense of a criminal defendant and getting public records, DHR records, to try to exonerate somebody's client. That's not what we have here. It's not a criminal case. This is a child dependency case, and the pattern and practice has been for DHR to supply those per your order, and that's not been done in this case. And we'll address more in my motion in limine, but I'm asking also that anything that might be on those records not be able to be used here today in testimony or admission into evidence. We've not had a chance to inspect those records. And I think even if you did an in-camera review and allowed us to attend, that would have been fine. But we could have gone over the records together. But they're not producing, and they're due to produce them. That's all I have, Your Honor.
Ms. Miller?
Judge, I don't have anything further.
Your Honor, the purpose for citing the variety of statutes, as well as to point out that this is not something that is just with regards to child welfare records. But again, all of DHR's records are confidential. And even in a criminal case, parents do not have necessarily unfettered access to their records. And again, that is part of the purpose for producing all those criminal statutes. There are limitations on what is able to be produced. As far as some of those records, for instance, the mental health records that have been brought up, Mr. Holm knows where those medical records are. Mr. Holm has been able to get those medical records if he elected to. Mr. Holm has had the opportunity to issue a subpoena for those records if he elected to. He has had access to the majority and probably has copies of the majority of those records. Again, those are not necessarily the records that DHR should be in the business of turning over in general anyways, because again, they are not DHR's records. We cannot necessarily speak to their authenticity. There are other issues that go into that. And again, those are all things that the Holms have had access to. Those are all things that, again, I think the court can weigh the fact that they have apparently elected in the last week to not try and get copies of those either. And they have known that. Mr. Holmes signed that release. He's known since the date of the signing of the release that the department was going to try and get those records. He's done nothing on his own to attempt to get those records. And again, we do acknowledge that it is the pattern and practice of the agency to give those to licensed attorneys, because licensed attorneys, we believe, will follow the rules. It is also the pattern and practice in this case that the rules are not necessarily followed, and that information regarding this case and what is happening in this courtroom is being divulged to the public. And there again is the agency's concern, and we have, when asked, provided that proof. We have provided the information. I understand Mr. Kirby doesn't like it, but again, that is what is being done in this case, and that is the agency's concern.
Your author, I think Mr. Schlenker addressed the authenticity of his records, basically saying that they can authenticate the records. But
We're not arguing that part right now.
right, I understand that. But the records that DHR has and plans to introduce at trial should be, and if it was done with a valid HIPAA waiver, and that's an argument that we have too.
Okay, are we doing all these arguments together? Because right now we're doing the alter amend and your response.
Right. Well, I'm using the HIPAA part as part of my response to Mr. Schlenker's statements. We don't know that's a valid HIPAA release. Matter of fact, I don't think it is. Just from the short time that I had to view it on December the 5th, that's part of the DHR records. That's something that should be turned over to us. That's not something that he can go to Savannah Counseling, where they got these records and get it. That's their records. What else is a part of their records that we don't know about? We have the right to see those records, to see what everything that's alleged.
Judge, I just have, I guess, more of a quick question. I know when we were here last time, and correct me if I'm wrong, I think, Mr. Kirby, where you provided access to those, specifically those counseling records from Savannah Counseling?
For the short time,
Okay.
the short time just prior to trial, for an opinion as to a GAL.
Okay.
That's the only time I've seen those records.
Have you made any contact with prior counsel records to obtain their file?
I did contact Miss Argo. Miss Argo said she would have to look for those records. We called her again yesterday. I've had no response from Miss Argo. I did not contact Miss Wilkinson, but certainly the department can answer if they gave those records to either Miss Wilkinson or Miss Argo. I don't believe with the short time that they were a part of this case that the department produced those records to either one of them. I can't speak for either one of them personally and know that they don't. I know that I did request of Miss Argo that if she had something to please get that to me. And we called, that was last week, we called again yesterday there, and Miss Argo she wasn't there, she wasn't available, and I don't think that her assistant could find anything. So I'm not sure if they were provided to them or not. Oh, well, the Holms apparently made a request of which one was Jennifer?
Jennifer Argo.
Okay. Made a request to Miss Argo to get the records and get any records that she might have, and they've not been given those records either. And like I say, they didn't even have record of their court filings until December the 6th.
Anything further from the state?
No.
Anything further?
I just would like to know what's going on.
Well, they're bound by the order, I think. No, ma'am.
Mr. Kirby, you also mentioned your argument about holding DHR in contempt. Do you understand that would be a separate, if you so elected to choose, correct?
I do understand that. Yes, ma'am.
I have real concerns about things that may have been disseminated on social media. I don't know where it came from. You can sit there and say they can't identify this child, but if it's identified as baby boy Holm or baby Holm, we have a small community. Come on. People can identify that it is indeed Mr. and Ms. Holm's child. Concerning. If indeed it is correct that what was relayed or read into the record, as far as these two exhibits, which would be states 6 and 5, which would be the picture of Mr. Holm purported to be but not admitted, and Mr. Holm's purported counseling notes not admitted. If those were indeed the documents discussed, then it would only have come from someone within this courtroom. Further, the court has concern if it is noted on social media that we had a improper meeting. Mr. Kirby, you were also part of that meeting with standby counsel, and that was explained. As a matter of fact, I think you came out and said, "Hey, we forgot these are pro se parties because we are just so generally."
Yes, ma'am.
But nonetheless, they were represented in that one little meeting, and if there's an issue with that, we need to address that, and we need to. I'll give you ample time with your clients to address it. As far as the reference to an FBI investigation, there is some document filed, but I wasn't real sure what it was, other than a thing filed by the parents. It certainly didn't have and that may be the manufacturer's statement that we were discussing earlier. But nonetheless, there is information being leaked out concerning. What I'm going to do is, I'm assuming, or would hope, that the department has a copy of their records with them.
Yes, ma'am.
We're going to take a moment, and we're going to go over this, and I'm going to review them in camera with Mr. Kirby and Mr. and Ms. Holm, if they want to be in there, and we'll take a look at them and see what's there, and then I'll make a determination from there. I am going to go ahead at this time and say that I'm not happy with the department. I don't remember when this baby was taken into care and when we started this proceeding, but it is custom and practice of this court to enter a standard motion or a standard order of production. I don't know whether or not that was complied with as far as prior counsel of record, but the department did not choose to move to amend their record until December 9th, and again, I don't know what happened there to precipitate that, if there was some filing on or something that appeared somewhere on social media, that, because I haven't been perusing social media either. Mr. Kirby, I guess it's just a technology and age thing with us. And then the parents' response to that was not filed until later. So that seems to be what triggered the response. And yours may have been, it may have all accumulated with your office going up to attempt to get records.
Yes,
I don't know. So I think that at this point what we're going to do is that we're going to stand in recess, and Mr. Kirby, and certainly a counsel for the department and the guardian want to be in the review, so be it.
Now, Judge, let me ask you, if Mr. Slinker says that he's got the entire department file, does he have all the caseworker notes and ISPs and all that stuff?
Okay.
So I see they came prepared to do so. All right.
Very good.
Judge, if I could go get a drink.
All right, we are back on the record. I'm JU8801. After doing an in-camera review of the records with counsel and the parents and the guardian ad litem, the counsel for the parents, Mr. Kirby, made some notes here that I guess Mr. Hamlin reviewed these notes.
No, I don't think he did.
Okay.
No, I didn't look at that personally.
All right.
I marked the records that I thought we needed in,
Okay.
and some of them are multiple page records with just a notation on the first page.
Mm-hmm.
Just like the counseling records. I marked those
Okay.
as one thing that we needed, but it includes all those 90 pages. Are we on record?
Yes.
One thing that I did not see in there, and I would like to know where it is the affidavit that was used for the pickup order. It's not of record in the court filing, and it's not in there. That's the reason I'm not so sure that that's a complete DHR record.
When you talking about affidavit that's used?
On the juvenile pickup order, it says a sworn statement or affidavit was submitted, I guess kind of like a search warrant. A police officer has to swear or have an affidavit saying why he needs the search warrant.
Evidence and facts.
That was one of the things that was on the juvenile pickup order that was checked, that said that there was a sworn statement or affidavit made to get the juvenile pickup order.
And I may be able to answer that question. Generally, in what I have done in my standard pattern and practice is when there is an emergency situation or deemed to be an emergency situation for a pickup order, what the department has done is sent a caseworker up here. I put them under oath in front of me and have them tell me what is the situation that gives rise to the emergency that would denote a pickup order as opposed to a summary removal.
Okay. Well, who would that person have been in this case?
I believe Stacy Jackson, without me looking back
I
at
think it
it.
was Carrie Pollard, Your Honor.
May have been
Carrie
Carrie Pollard.
Okay.
You want to do the records thing first and then let's do that?
Yes, ma'am.
In reviewing these records, there are several things. As a matter of fact, the multitude of these records are things that would have been available readily to the family, the parents, individually or collectively. In particular, a lot of them seem to be records that may or may not have been generated by Mr. Holm or the counseling notes, Savannah Counseling. Those are certainly his records. He knew about them. He could get them. There are a few, and you've made notes here, Mr. Kirby, on these. It looks like the narrative of the department,
Yes, ma'am.
and things like that. And I do think that, that is something that should be turned over to the parents and council. However, with that, these are confidential records. Not for Facebook, not for friends, confidential. And I don't know that I can make it any clearer than that. And Mr. Kirby, what our standard practice has been is that we give the records, we being loosely, my order says, DHR, give it to the lawyer who gives it to the client, works with the clients. And that's where I would like to go with this, so that we keep the standard practice and pattern, especially now that you're co-counsel.
Yes, ma'am. But, Your Honor, obviously the Holmes don't want to continue this case, but I think there's important records in there. Of course, we reviewed them and made
Yes.
notes, but we didn't have a chance to examine them thoroughly. And I don't want to delay this action any further. So I'm not quite sure what we do about that. They should have been, those records, by the admission of the court, some of those should have been produced to us, especially, I guess, when I requested them. And they weren't. And I maybe we can address that in my motion in limine, because I think I asked for any and all records that the state didn't produce to not allow any testimony concerning that or be used.
So are you arguing your next motion?
Well, I'm just saying we can get to it in the motion in limine, but that's what, they, in my opinion, they couldn't.
I'm going to give these to you because they have a lot of your notes on them,
Yes, ma'am.
rather than me holding them up here and looking at them.
Thank you. But, it's just like, it's like with any defense of any motion, if you are at any trial, if the other side withholds records from you that you're due to get, you can't build the strongest defense, I guess, that you could possibly build.
So you are, at this point, just very clear, the motion to alter amends denied, you have the records now.
Yes, ma'am.
Okay. Just get it clear in my mind. So the next motion that I have is the motion to produce evidence of service.
Yes, ma'am.
Okay. So if I don't go checklist it down, I'll forget one, I'm afraid.
understand.
So, Mr. Kirby, are you arguing that motion? I don't.
Yes, ma'am.
All right, I did not set it for hearing. That was my mistake, but we're here. Department had notice of that. It was filed the 9th. Is there any objection to the department about, let's go ahead and take care of that motion?
Judge, let me look at this one. No, ma'am. No, ma'am.
Okay.
We're fine to take this one.
All right, Mr. Kirby, go ahead, or Mr. and Ms. Holm, whoever.
You okay with me arguing this motion? Okay. Judge, we file a motion to have DHR produce all evidence of service on the Holms. The Holms they were not notified. They weren't given their records. They weren't notified of court filings, especially subpoenas that went out to Savannah Counseling. They weren't notified of any motions filed by the department.
Okay, what time frame are you talking about?
Well, I don't think they've received any motions. The only thing they've received is starting with your order that addressed the ex parte filing of DHR caseworkers. They've received orders since then, but they haven't received any motions since
Okay, and you're talking about
up until December the 5th.
Okay, let me go back and look.
And if I'm correct, that's November the 15th.
All right, so up until what point, let's see, up until November 3rd, they had counsel.
They had counsel, yes.
And if counsel got or didn't get motions to them, that's between them and counsel, is my theory on that.
I understand that.
Are they saying they didn't get things from Ms. Wilkinson and Ms. Arda?
That is correct.
And when they terminated their counsel, did they come in and make a change with the court system as far as their address?
Evidently, there was a change made to P.O. Box 243?
438.
438, I'm sorry, in Wedowee, because they started receiving the court's orders
Okay.
at that time. But they did not receive any motions, subpoenas, or anything else from the state.
Let me see when the change was made in here, if I can tell you. Notice of intent on the non-party subpoena was filed by Jennifer Argo. That was in November. Before she withdrew. Says 11:15, HIPAA order issued, copy mailed to attorneys of record, copy mailed to Danielle and Christian Holm. That's on Estes.
Okay.
Now, whether or not the clerk's office had their correct address, I cannot tell. What would be the correct address on here? And if Mr. and Ms. Holm did not come up here after they relieved counsel, and again, I understand they're uneducated in the law. But I'm trying to see what else is here. What other motions?
Well, we did go-
And it may be, then there was
Judge?
a motion for restraining order, copy emailed to attorneys of record, copy emailed to Cleveland County DHR, copy mailed to Christian and Danielle Holm. So it appears that the clerk was sending it out, and I'm not seeing where anything was returned.
Yeah, there is, but what address was the clerk sending it to? Because I have a juvenile pickup order here that that it's supposed to have been served on Danielle and Christian Holm.
Mm-hmm.
The address is Cheehaw State Park, and I believe the clerk would.
And Judge, if I could interject, I was looking back at the petition, and that's actually where their address was listed.
Mm-hmm.
So,
And counsel was appointed at shelter
But
care.
Judge, if you'll notice too, there was no service of the petition on the Holms.
The Holms, okay, it's my understanding that this is the procedure in juvenile dependency, and please correct me if I'm wrong with your understanding. Once a parent makes appearance, they are deemed served.
Yes, ma'am.
Whether it is shelter care, adjudication, whatever phase of the proceedings. And personal service is not necessarily needed after that fact. Mr. and Ms. Holm were here at the shelter care. They were represented by counsel. They testified. Copies of the petition are historically given to counsel of record at that time. And I would have no reason to believe that Ms. Argo and Ms. Wilkinson did not have the copy of the petition to go over with their respective clients at that time.
Well, it's shelter care here, and my understanding was there was no petition available. That's my understanding. Now, I was not here. The only thing that I think the Holmes said was available to their counsel at the time was the pickup order.
I don't see petition was dated 10/11, it looks like. File with court 10/11, 5/18. Petition was dated, I would have no reason to think that, and again, it's the standard pattern and practice, is that copies of the petition are made and given to counsel of record. And if you've not talked to Ms. Argo and Ms. Wilkinson about that, and I need you to tell me, where are you going with this motion? What do you need from me?
I'm saying that just like this, the motion to order, or motion for order to compel the parents to cooperate with the Cleveland County DHR. There's no service of the parents on there. The only people that were served with it were Tony Hamlin, Carrie Pollard, who's listed as a pro se litigant in this matter, and Allison Miller. There's a subpoena request.
And that motion was deemed moot at the last hearing.
I understand that.
Why was this issue raised then?
There is a notice of intent to serve a subpoena
Filed
on
by?
Savannah Counseling filed by the department on 15th of November. Notice of service went to Allison Miller and Tony Hamlin. No service on the parents.
Okay, and just for the record, when those are pushed through the court system, I don't even look at them. I just, no action those. So I would not have looked at that.
Okay, but what do we do about the parents not having an opportunity to quash that subpoena? I mean, if they'd received notice of the, if they'd received notice of the motion, then they could have at least filed a
Okay.
motion to quash.
I understand.
Here again, let's see. That's the HIPAA order. It shows State Park, Cheehaw State Park. motion by the state. Of course, it's been denied, but there was a motion by the state to appoint a guardian ad litem for the parents. Says notice date 11/17. And by 11/17, the court was aware of, or the clerk's office was aware of where to mail anything for the parents.
So they would have mailed an order, but not necessarily a motion, because it's not the clerk's responsibility to mail
It's
motions.
not the clerk's responsibility to serve that motion. It's the state's responsibility to serve that motion on the parents. Oh, let's see. What I'm saying is that the parents haven't been served with the motions as attested to on the state's on motions. Down at the bottom, they put a certificate of service, and I mean it's standard practice pretty much for all attorneys to notify who's been served with the motions. The parents were due the motions. The state said they served the motions. I wanted them to bring proof in here that they served motions on these parents, and how they tried to serve them. Did they try to serve them by mail and it was returned? If so, I can understand that. If not, I don't. If they didn't try to serve them at all and they're attesting to the fact that they served it on all parties pro se or the attorneys of record.
Mr. Slinker? Hey, what's that? You're done?
I'm done.
Okay, sorry.
Judge, the uncontroverted testimony in this trial so far is that the Holms have not provided an address to the department, to the GAO, or to the court even. The address that the clerk's office is using is really generated by random by one of their 34-page filings where it happens to have a P.O. box on there. There is no idea by the department to this date where they are at. The last address that we have for them comes on November 3rd of 2016 in a filing by their attorneys when they were withdrawing of 1000 North Beeline Highway, number 252, Payson, Arizona 85541. That is their address. They have not updated anyone else with that. We do not know where they live. They have refused to tell us that. They refused on the witness stand to tell us that. They have unclean hands to come in here and argue that they have been denied an opportunity to notice when they themselves have denied themselves the opportunity to be notified of anything. Again, the only address that the department has currently for them would be 1000 North Beeline Highway. That's it. We don't know if that P.O. box address is correct. We don't know what is correct. We don't know. One River has them living in Georgia. We don't know where they live. We don't know how to get in touch with them. We have a phone number they occasionally will answer. Well, that's not good enough for service of process. So as far as my motions have been done, they've been filed to 1000 North Beeline. They've been mailed to 1000 North Beeline Highway because, again, in the file, that is the last address of any document of anyone of record for the parents.
Okay, and that address was gleaned from the motion to withdraw by counsel from one of the parents.
Correct, on November 3rd.
Okay, which is the way that you are supposed to do a motion to withdraw.
Judge, and it is also the address that the mother used in her medical records when she went to the hospital. So apparently it is an address that they have used on multiple occasions.
So, we came in, we argued these motions that Mr. Kirby says my clients didn't get. State has a valid point. We sent it to this address right here, and I do remember very clearly. Of course, Ms. Holm hasn't testified yet, but Mr. Holm saying, not giving you where I live. Nonetheless, with all that, we are now to the point of these recent motions, which would be the motion to alter amend. Did you receive that?
I did receive that. And I did pass that on to the Halls.
Okay, so since then,
Yes, ma'am.
is there a motion hanging or pending in the in-between that we don't know for sure about notice? Because I think I just went through and cleared up everything, with the exception of the 18-page document Mr. and Ms. Holm filed,
Right.
and I wanted to make sure that wasn't a motion that needed to be argued. So my understanding was everything had been
Right.
taken
All the
care of.
motion, I mean, the motions have been addressed. You know, I guess my question, Your Honor, is if the clerk's office can get a good address for the Holms, then why can't the state? And they put on their certificate of service that they've served them. Well, they didn't put where they tried to serve them. All it is says generically, I've served this on council of record and all parties pro se. It doesn't, just like on the Holland certificate of service to the state, it notices both Mr. Hamlin and Mr. Slinker and Allison Miller. That way, if there's a question about address, then we know that there's an issue. When you generically certify that you've served all of this stuff on any party, you're opening yourself up to this. I guess most importantly, what we would argue would be the notice of intent, the 15-day notice of intent of the subpoena to Savannah Counseling. They would have received no notice, but by that time the clerk already had their P.O. Box 438. We doubt. That's a good address. The Hollands have been receiving orders from there, but they've not been receiving motions.
But by the same token, did the Hollands give an updated, even a P.O. box to the department?
Well, they must have, because the clerk picked it up.
I think the clerk picked it up from something that was mailed in here.
Okay. Well, if the clerk picked it up, then the state should be able to pick it up.
Judge, we would ask for them to provide proof that they've submitted to the court or to the department or to the GAL a updated address, not on some random thing that they've sent into the courtroom, but that might be just a return email or a return address that is not updating this as our mailing address. Because again, that is what my contention is. They have not told anyone where they're living. We have no mailing address for them other than by pure supposition, and that's not good enough.
Okay, and at this point in time, it's my understanding the parent's contention is through Mr. Kirby, P.O. Box 438.
Wedowie,
Is that the correct box?
Yes.
That's correct.
Wedowie, what is that zip code?
36278. Your Honor, I'd like to ask Mr. Slinker a question. Did either you or Mr. Hamlin get the notice of the civil suit by the Hollands? Either a first or second notice? Have you seen that, haven't you?
Have they actually filed suit, or are you talking about?
No. It was a notice. It was a notice that the Hollands sent out to
Okay.
government agencies that had their address at the top of it.
Without these being admitted, without these going into discussion, is this what you're talking about?
Yes, right here. Were you given this?
I've seen that.
You've seen that? What the PO? What's the address at the top?
He's not under.
I know he's not done, but I understand. I'm sorry. I let it. But their address is at the very top of that.
Okay.
I'm sorry, Mr. Schmidt. And if you say you mailed something, then you ought to have proof that you mailed it.
We have ours.
You put it in, Judge, you put it in an envelope, you mail it. I mean, the proof is the certificate of service. I hereby certify that I have done this.
Well, and I guess the bottom line is, and I certainly don't know that this is going to be the contention of the department. They being Mr. and Ms. Holm, could possibly have someone in, where was it, Arizona, to pick up their P.O. box. I don't know.
Actually, it's forwarded.
Forwarded, okay. So if it's forwarded from Arizona to here, are they saying we still didn't get it? And at this point, I understand that your aggravation factor in.
Yes, ma'am. I'm sorry.
I really do.
I apologize.
Because it appears that, that there were some motions filed that Mr. and Ms. Holm did not get adequate notice of. With the exception of that 15-day non-party that they could have objected to.
Yes, ma'am.
Everything else, that's the crux of the
Yeah,
issue,
the-
from
yeah,
what I'm
well,
understanding.
yes, that mainly, you know, of course, I want, if you file something and you say you served everybody, I want you to mean you served everybody.
Well, I mean,
But-
if the department is saying we sent it to this Arizona address,
Yes, ma'am.
this Arizona address, and Miss Holm are saying there was a forward on that, then at this point, I'm going to assume the department is asserting correctly that they mailed it.
Can we see?
But at this point, you know, I saw Mr. Slinker taking a note, so I'm assuming you changed your address to put in your file.
Yes, ma'am. I have their address now, and Judge,
We want evidence.
obviously, now that Mr. Kirby is there, that will assure that an attorney
Yes.
record on their side is served with everything.
Yes,
Well-
that pretty much has cured itself since the 5th.
Right, it's cured itself, but there again, Your Honor, they were not allowed to, they were not served with the notice, 15-day notice, which they could have moved to quash, and of course, we want to move to exclude those records, but,
Evidence. You can show evidence.
So what relief were you looking for, or
I'm
were you
just-
just making the court aware?
I'm making the court aware, but I also want, I know,
And let's go motion by motion. So
Right.
we're still on the motion.
We're still on the
to bring
motion.
the evidence that they
Uh,
sent it.
I'm sorry, if I keep going, I'll
It's okay.
upset the court, and I'm upset right now, so.
Well, no, it's not that I'm upset. It's just I'm trying to make sure I'm staying in order so that I don't skip something.
Okay. I just wanted to see evidence, maybe a copy of an envelope that they sent to the Holms.
Judge, I don't make copies of envelopes. It's not our pattern of practice. Maybe it's foolish on my part, but I'm not aware of any attorneys who make a Xerox of every letter that they mail and then slide it in the file. Maybe that's Mr. Kirby's practice, and that is not mine. It's not required by the rules.
That's correct. It is not
Oh, I
required.
understand it's not required by the rules.
You already admitted to certificate, let's see them. You already admitted to having certificates, so let's see them.
Well, we were just looking for any evidence that they might have served the Holms with anything in this case. I guess, my frustration is, Your Honor, when I first met the Holms and we were in trial last Monday, they had not seen anything. Now, whether it was provided to their counsel before, they did not have copies of anything. And one of the things in going through with assisting them was determining if they were served with anything. And we found that they were not served. Even though the motions had been decided and the point of the motions is moot now, they hadn't been served with the records of filings. That's my concern, and I'm gonna leave it at that.
Okay, but since then, since you were on board, the clerk put you on the 5th, I believe.
Yes, ma'am, I think so.
Is there anything that you know of that you have not gotten?
No, ma'am, there's nothing that I know of that
And you in turn have passed that along to Mr. and Ms. Holm?
I have passed that. Everything that's come out of this court, any kind of filings, orders, whatnot, on to the Holms.
All right. So we have, I guess, argued everything, and I don't know, Ms. Kirby, if you're looking for a ruling from me on the motion to produce evidence of service, or again, like you just said, it's more of an informative situation to the court, and it appears that it's going to hinge hand in hand with other motions that you filed after the close of business yesterday.
Yes, ma'am.
Okay. That makes
it is
sense now.
informative, but I would want them to bring those up. But if it's going to work hand in hand with other motions that I filed, or
So,
the Holmes have filed.
I'd like to have on record the MSO. I'd like to have that.
make sure I've got everything.
Don't worry about it. Okay.
All right, I have left then the totally pro se, motion to dismiss, and amended motion to dismiss that was filed, I believe, on maybe the 6th, right after the first hearing. that Mr. and Ms. Holm filed, the one that they filed, a handwritten one, and then the second one had a lot of documentation filed behind it, that you said earlier, we'll just argue that all at one time.
Yes, ma'am, that's fine.
Then I have a motion to dismiss filed by last night at 4:54 p.m., consisting of 4 pages. And after that, at 5:47:52 p.m., a motion to suppress testimony and records in limine, and that consists of 15 pages.
Yes, ma'am.
So, without and that's just clicking down my list on S's here of things appear in order. Are there any other motions pending that you're aware of?
Not that I'm aware of.
State?
No, ma'am. That's all I see.
Guardian?
No,
Okay, so we have the motion to dismiss that was filed last night, the motion to suppress that was filed last night.
No?
I'm sorry. I didn't hear
Do you
that.
want to proceed with those now? Do y'all want to take a little break for lunch and come back?
I don't, it shouldn't take 30 minutes to at least get
I
one
see.
motion out of the way.
I think you go.
Okay.
Judge, and before we begin, with regards to the motion to dismiss petition for dependency, that is substantially than the petitions that were filed by the parents. And looking at Rule 6, the state is entitled to 5 days' notice of this motion. It argues a variety of different things, and again, the state has not been provided an opportunity to prepare for that motion and having ample time. It was filed at 4:42 yesterday, and again, the counsel for the department did not see it until this morning.
What rule are you?
Rule 6, for motions, affidavits, a written motion other than one which may be heard ex parte, and notice of the hearing thereof shall be served not later than 5 days before the time specified for the hearing, unless a different period is fixed by the rules or by order of court.
And since that was set or submitted after close of business yesterday, it was not set for hearing by order because I didn't see it till this morning to set it. Let me look.
Well, I mean, it addresses a very simple issue, Your Honor, that's documentary in nature, and it's of the record, so it's not like we'd be introducing any evidence. The state shouldn't need 5 days to prepare for it. So if the court, I guess, so ordered, we could move on with it.
Well, I think that's one of those, if they object that they don't have, that it's procedure, that it is different in the body of it, and that they didn't get 5 days notice, that I have to give 5 days.
And Judge, there is no requirement under the rules that counsel has to work 24/7 in order to be ready for a trial. So, I mean, realistically, counsel has been provided for the department about 10 or 15 minutes to look at this, and again, without having sufficient time to prepare for it, because it does reference a statute that I do not have a copy of in front of me. I need more time than just, all right, here we go, let's tee it up.
Wait a minute.
Okay, and
You're talking about referencing the statute requiring a child custody affidavit?
These are things that you should know.
I do not.
If you don't have time to look it up, it's there on the motion. It's
While I appreciate Mr. Kirby's ideas on how long it's going to take me to research, it is not for him to opine as to what I should be entitled to do with regards to preparing for a motion. Obviously, he has taken a substantial amount of time in preparing all these motions as they've continued to flow in since the last time we were here. If he had known he was going to file this motion, he could have filed it certainly before last night at 4:45.
It
Yeah, I
does.
guess, oh, I'm sorry, go ahead.
Go ahead.
I guess you could set that out and not hear that today in case, if this case goes any further, then you could hear it then.
Well, and it does appear from the face of what was filed last night. It's very, very different from the pro se filing of mom and dad. I'm sorry, Mr. Miss Holm.
Do what now?
I called you mom and dad, and I said, I'm sorry, Mr. Miss Holm. When they filed their first motion, their handwritten motion, and their amended, which appeared to be the handwritten motion. So it's very different in the substantive nature of it.
But that's been plenty of time on that one, though, right?
On the
On
pro
ours.
se.
Yes. So, the motion to dismiss last night filed at 4:42. We're going to have to set that for another hearing because the department has not had 5 days' notice.
Contingent upon the outcome, yes.
And that's fine with you?
That's fine.
Okay. Now, as far as the pro se motion to dismiss, is that something that needs to be argued now or later?
I think Mr. Holm would like to argue that now, would you not?
Yeah, we would.
Okay, and that's going to be a separate, because it is, from what I'm reading, very separate and distinct in what is within the one that you assisted them in preparing, which appears to be more of a procedural, legal, here's your statute argument.
Yes, ma'am.
So with that being in mind, let me make myself a note here.
Okay.
So the 442 motion, so we'll set that for argument by separate order. And the motion to dismiss filed, I believe, on January 6th, and the amended motion is filed by Mr. Ms. Holm, is the one that we are now going to hear argument of. Mr. Slinker, the department has had ample notice on that one.
This one?
Yes, ma'am. I'm just trying to make sure that I can hold them up, Judge. 'Cause
Okay.
Yeah. Okay. I'm trying to make sure that we have the right one here.
You're fine.
All right. I guess that this motion is based under lack of evidence of child endangerment. And under common law that we are the manufacturers of our child. Our child is our product under law because we created our child under a creator and no one else did. So we claim lack of jurisdiction and we call on the life salvage law to retrieve our product.
I'm sorry,
The life salvage law of common law
okay.
to retrieve our product or our property. And we have a manufacturer's statement of origin. And not that we consider him, well, the law considers him as our property. And that we demand for him to be restored to us immediately without any further torture, punishment, coercion, interruption, and involvement of the Department of Human Resources. That's all, Your Honor.
Mr. Slinker?
Your Honor, the reason why we're here today is for a trial, which is to gather evidence with regards to whether dependency exists. So, in some part, the motion is premature. Additionally, common law in a great many ways has been supplanted by statutory law, and the statute clearly has been invoked in this case, and this court clearly has jurisdiction, and a manufacturer's statement of origin does not override the statutory rights of this court and of the state of Alabama over a child who's found within its jurisdiction to ensure the safety and welfare of that child. And again, that is the purpose of this hearing. We understand that Mr. and Ms. Holm do not agree with that. But again, we are in the middle of trial for that very reason, and that is That will be ultimately the determination of the court, hopefully sometime today, if not tomorrow, whether or not it meets the statutory definition of dependency, at which point in time, and then we will go from there. But again, otherwise, this court absolutely has jurisdiction, which I think is kind of what he was arguing. And then also, again, the case is not closed, and so a lack of evidence is premature.
Anything further, Mr. Holm?
Yes, I would like to state that there is nothing on record showing for the court and or DHR to have jurisdiction over our child. There's no social security number, there's no birth certificate, there's nothing that's claiming any other organization to have jurisdiction of our child. And if there is, then we did not consent of it, and we would like to see the law that states that y'all, or that the DHR and or courts has jurisdiction of our child now. That's all.
And I believe, Mr. Kirby, as counsel, you can certainly give advice as to what the jurisdictional law provisions would be. Anything further from the department?
No.
Guardian?
Nothing
At this juncture, we have already started testimony. I do think the motion to dismiss is premature or not right for adjudication because the state does have the right to present their case in their entirety. What I'm going to do is just withhold ruling on that, other than for that purpose, let the state proceed on. And then, of course, Mr. and Ms. Holm will have the opportunity to renew that motion if you so choose at the end of the state's case.
Yeah, that's right.
Okay?
Thank you. That's fine.
All right. So, now we're down to... The last thing I'm showing is a suppressed testimony and records motion in limine that was filed last night at 5:47. And I just lost internet service.
Judge, that one might take a little time, but
That's what, I mean, that's a rather, as soon as I get my internet service back, I can tell you it's a rather lengthy Mr. Kirby motion. Just a minute. Almost 20 pages, I believe. 15.
That's all.
ma'am, I'm sorry.
15-page motion.
Yes, ma'am.
Okay, with that, since you're saying that's a rather lengthy motion, it's now 11:38. Do we want to take a break for an hour and get some lunch and come back at about 12:45?
That's fine with me, Your Honor.
Okay.
Okay.
Whatever the pleasure of the court is, Judge. We can go forward or not right now.
That's fine with us.
I know if we go forward, I need about 5 minutes.
Let's just take a break.
Okay.
12:45, I think, will be good.